So we have an important update in a fight to strike down a state suppressor ban. A case is now in front of the 7th Circuit, and while the case could be one of the first ones in the nation to strike down a state's outright ban on suppressors, the state here is continuing to delay this appeal, and the court is continuing to allow the state to get away with it. So let's talk about what is happening in this critical suppressor case. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. Also, I want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm's an amazing company, pro-freedom, pro-America. They support the Second Amendment and what we talk about here on the channel, but also they have amazing supplements. So if you're trying to get healthier, if you're on your New Year's resolution, like me right now, I'm trying to get healthier, working out more. I've lost 18 plus pounds since the beginning of this year. And a lot of the supplements that I use come from 1st Phorm. So if you're interested, check them out using the link down below. And if you use that link and you order any supplements, you can get a free 5-pack of protein sticks. Now, as I mentioned in the intro, in this video, we're going to be talking about a critical suppressor case that is currently in front of the 7th Circuit, and it deals with a state's ban on suppressors, the ownership, purchase, and possession of those items. This case challenges Illinois' outright ban on the purchase and possession of suppressors. And as you know, most states actually allow the ownership of suppressors, but there are some jurisdictions, about 9 jurisdictions, which prohibit them entirely. Now, in this case, the plaintiffs argue that Illinois' total ban violates the Second Amendment under Heller, Bruin, and a lot of the other case law that is developed in the Second Amendment realm. But the federal district court on review of this case dismissed the case for a failure to state a claim, I believe. And essentially they said that the items here, that suppressors are not protected arms. And they said that the plaintiffs failed to show that there was a historical analog from the founding era time period. The court's reasoning and ruling in this case was very striking and very concerning. The court held that unless there was a colonial era or 19th century precursor to suppressors, these modern suppressors are not protected at all by the Second Amendment. So in other words, the district court found that no historical twin of an item then means that these items are not protected. And that is not at all what Bruin said, but here the lower court twisted Bruin to come to this conclusion and this ruling. But again, Bruin does not require a founding era prototype for every single modern type of arm. And because of this horrible ruling by the district court, the plaintiffs have now appealed this up to the 7th Circuit, and they're asking for the 7th Circuit to strike down that ruling. Now, in this case, the plaintiffs' core arguments are that the Second Amendment protects all bearable arms, including modern arms as well, like suppressors. Just like the First Amendment protects the internet and the Fourth Amendment protects digital searches, the district court should have also found that these modern suppressors are protected, but instead they created a new test. It said that suppressors are mere accessories, not arms, and it suggested only attachments that are integral to the firearm's function might qualify. Something like magazines or optics could qualify, but they said suppressors did not have a historical analog, a precursor item that existed, at the founding, and therefore they were not protected. And again, that analysis is very concerning. That's concerning because it opens the door to stripping protection from modern firearms components if you cannot identify a historical ancestor dating back to something like 1791. And that is the issue that is now before the 7th Circuit Court of Appeals. But here's now what is happening in this case as it's escalated to the 7th Circuit. The state of Illinois has repeatedly delayed filing its response brief to the 7th Circuit. They were supposed to file their response to the opening brief that was filed by the plaintiffs here against the state of Illinois and the suppressor ban, but the state of Illinois continues to make excuses and delay their response. The response was originally due back in December, I believe December 3rd of 2025, but since then, they've requested a 30-day extension, then another 30-day extension, then a third 30-day extension, and then they also just requested a fourth 30-day extension, which they were granted. That means that they've now received over 120 days to respond to the plaintiff's opening brief, and the plaintiffs initially, in this case, did not oppose those first 2 extensions, but on the third and fourth requests, the plaintiffs here pushed back and said that the court should not allow this to happen, that this is ridiculous, and that the state here is just making excuses to delay this case. They point to that under the 7th Circuit's Rule 26, extensions of time to file briefs are not favored. The rule requires showing that with due diligence and prioritization, filing on time is not possible. Now, the plaintiffs argue that the state keeps citing the same deadlines in other cases, including a February 9th deadline that the council has known about since back in December, and also now that deadline has come and gone, but they continue to use that excuse to get additional 30-day extensions in this case, so essentially they can delay this and not respond to this issue. In short, these deadlines were known for months. The state has already received 3 extensions, and the only justification offered is essentially its workload in the same cases that they say they've been working on for a while. The plaintiffs are now asking the 7th Circuit to no longer delay this case, give them no more extensions, and allow this appeal to finally move forward. Now, why does this matter? Well, this is not just about procedural issues. This shows that the state of Illinois and also the 7th Circuit are just trying to delay this issue for as long as possible. Every delay slows down the resolution and slows down the opportunity for this to be resolved and potentially residents of Illinois to be able to finally purchase and possess suppressors. The longer this appeal drags on, the longer Illinois residents remain barred from exercising what the plaintiffs argue is a protected right. The longer other states, essentially can now rely on what that district court said in that flawed reasoning. And the longer that the 7th Circuit avoids addressing this, core Bruin question, the longer this takes to finally make its way potentially to the Supreme Court. And I want to note, make no mistake about this, New York, New Jersey, and other states are watching this case, and likely they're going to cite to that district court ruling. They're going to try to rely on that to uphold also their state suppressor bans. And if the 7th Circuit affirms the district court's reasoning, those states will cite that also. But here right now, the strategy appears to be that the state and also potentially the 7th Circuit are simply just trying to delay this case. So this appeal is important for several reasons. It directly challenges a total state ban on suppressors. It tests whether lower courts can narrow arms protections using historical precursor logic, which again was not in Bruin. They're saying essentially this item had to exist at the founding for it to also be protected now. And it could create a circuit level ruling impacting other suppressor bans nationwide. And now instead of addressing the merits, the state and the 7th Circuit appear to be slowing this process down. But the plaintiffs are pushing back against this, and now they're pushing for expedited resolutions in this case. So now the 7th Circuit must decide whether it will continue to delay this case. It's going to be interesting to see now that the plaintiffs are opposing this, if the state of Illinois is going to request maybe a 5th or 6th extension of this and try to delay this even further, and what the 7th Circuit is going to say about that once that happens. And also, if the 7th Circuit finally denies those extensions, the state will finally have to actually file its response and try to defend its statewide suppressor ban. Then the case will get to proceed forward to oral arguments, and that's going to be a critical moment. But like I mentioned, regardless, I think this case will inevitably actually head to the Supreme Court, which Illinois and the 7th Circuit potentially know and do not like. So the strategy right now may appear to be that they would just simply want to delay this case for as long as possible, drag their feet so that this does not get any momentum and it doesn't make it to the Supreme Court as fast as possible. So that's what's currently going on in a critical suppressor ban fight dealing with a state suppressor ban out of the state of Illinois. It's in the 7th Circuit, but the state here continues to delay this case, say that they can't respond to this, that they don't have time, even though they've had over 120 days to file a single brief. And for some reason, well, really not for some reason, the 7th Circuit tends to be, anti-gun for the most part. They are allowing this delay. They're allowing this to be kicked down the road because they do not want to address this issue, because they know inevitably this will likely head to the Supreme Court. So as soon as the 7th Circuit finally decides to get off their butt and address this case and allow the suppressor challenge to move forward, I will let you guys know, but that's what's currently happening. Again, anti-gun, jurisdictions, circuit courts, and states are fighting back against the Second Amendment, and one of the best strategies they have is to delay these challenges for as long as possible. So as we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of 2A content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.